everyone, welcome back to the channel. My name is Varun Kaushal and I'm a legal intern at LEXIS and Company. Today I'm going to discuss about gender neutrality. The CLAA has also brought an amendment in the POCSO by amending section 42 of the Act. The purpose of section 42 is to give the general law of IPC an overriding effect over POCSO in the matters of punishment, since IPC provides for greater punishment for rape. The only caveat being that the act or omission must constitute an offence under IPC as well as the POCSO. For instance, for penetrative sexual assault, the minimum punishment prescribed under POCSO is 7 years imprisonment, whereas the parallel provision under IPC prescribes a punishment 10 years. If woman is between 16 to 18 years or 20 years if a woman is under 16 years of age. In such cases, the offender will be sentenced in accordance with the punishment prescribed by IPC. The amendment in POCSO was necessitated due to the inclusion of new offences in IPC added by the CLAA in order to extend the enhanced punishments in IPC in the cases falling under POCSO. Section 42 of POCSO was amended and newly created offences. Section 376AB, 376B, 376DA, 376DB were substituted. But in the process, the CLAA has failed to take into account the fact that POCSO is a general neutral law, whereas the legal framework of rape under IPC is a gender specific. To put it in context, POCSO uses person in its reference to victim and perpetrator, whereas section 375, 376 and other successive provisions use the word woman and man in reference to victim and perpetrator respectively. This will create a situation where those guilty of committing penetrative sexual assault on a girl below 12 years would get minimum life imprisonment or the capital punishment by virtue of section 376AB read with section 42 POCSO. But a lesser punishment, about 10 years or life imprisonment, will be given for committing penetrative sexual assault on a boy, since there is no parallel provision for rape of men in IPC. Some inconsistency will also prevail over gang rape related provisions, where the same offence committed against a boy and a girl will be treated differently. The CLAA, to the extent that it discriminates between sexes in the matter of punishment, fails to satisfy the Equal Protection Clause and is therefore violative of Article 14 of the Constitution. Moreover, it is also important to note that it is in the interest of justice that a public discourse be initiated for introducing gender neutral criminal laws with respect to sexual offences with appropriate mechanisms to check their misuse. Countries around the world have made suitable amendments in their criminal statutes in order to incorporate gender neutral provisions. There is an emerging consensus about the high prevalence of male and transgender victims of sexual offences. The criminal law is one of the most vital links which defines the relationship between a state and its citizens. Therefore, it is desirable if this relationship is defined precisely and clearly in the penal statutes. The criminal law, which is seen as the most potent state instrument restricting individuals' fundamental right to life and personal liberty, must be free from inconsistencies and ambiguities. However, of late, vagueness and ambiguity appears to be the first-hand rule of the present-day legislative interventions. The three aforementioned qualities of a good Code 65, which Macaulay valued, have been given a go by when it comes to legislative drafting. The ambiguous phraseology used in criminal laws reflect their want for precision. Apparent inconsistencies in criminal laws of India makes it difficult for ordinary citizens and even legal experts to understand the scope of a particular provision. On the one hand, IPC and its amendments continue to be subject to constant judicial interpretation, borderlining lawmaking due to slow progress in law reforms, whereas on the other hand, the legislature and the executive continue to sleep on the crucial law reform recommendations made by expert bodies and committees. Thus, the IPC and its recent anti-rape amendments continue to ail from ambiguities, inconsistencies, and legislative apathy towards its reformation. A hasty legislation drafted with an intent to calm public impulse may augur well for optics and political rhetoric. However, in the hindsight, it compromises the quality of law reforms and clogs the judicial system with petitions praying for an authoritative declaration on the law. The Parliament, which could have brought necessary changes in the IPC, left untouched by 2013 Amendment Act, has missed yet another opportunity by bringing superficial reforms. The state appears to have washed its hands from addressing the more pressing need for a comprehensive revision of the penal code. Moreover, the state narrative of deterrence is nothing but a misguided institutional aggression detached from ground realities. What is expected from any government is not mere passage of laws but to conduct through research, assess its findings, and apply reason before making any law. In the absence of a holistic research-oriented approach, the legislature will continue to pass ambiguous and omnibus law which disregards cardinal principles of criminal law, jurisprudence, and constitutional values. It serves well to all stakeholders in a criminal justice system to bear in mind that respect and adherence to laws can only be achieved when the lawmakers recognizes the necessity of reconciling individual rights with that of society, along with the state interest in maintaining law and order. That's it for today's video. Thank you for watching. Don't forget to like, share, and subscribe the channel. LEXCLIQ.